Thank you so much for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Shannon Bell, a Colorado construction lien law expert. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the fabulous Shannon Bell.
Thank you so much, Jessie. Thank you to all of you who are joining in today. We're going to kind of rapid fire going through the information. We've got a lot of things I want to cover. Just a quick reminder, if you have any questions, go ahead and use that GoToWebinar chat box on the right. We're going to spend about 20 minutes going through materials, so we're going to have some time at the end for you to answer questions. And as always, you can follow up with Jessie as to how to get in touch with me if there's questions, even after the seminar is over. One ask though, please, 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 let's respect the privacy of the folks on the call and do not include names, company names in the questions. So like I said, we are going to cover a lot today. We're going to be going through a couple of contract provisions. Saying, Shannon, I thought this was a lien and bond presentation, but I want you to be aware of some of these contract provisions as well, because they're going to be impacting this kind of overall issue on how to get paid and protect your ability to get paid. We're going to be jumping into securing your lien rights, some lien exceptions to be aware of. We're going to touch very briefly upon the overlooked and not very well known disburser notice. It's another place that you can try to get paid. And then if you're not on a private project, if you're doing governmental type work, or even on a private project that has a bond, a payment bond, well, let's touch base upon how you can get paid through a bond, and then getting that check. 4 different types of lien waivers. Just make sure you're aware of those before you sign them. And then we're going to turn it back to Jessie to revisit on some of the wonderful resources that SunRay has available for you. As I promised, we're going to touch upon some contract provisions. The first one, there are these competing contract provisions. There's a pay when paid, pay if paid clause. And I guarantee at least somebody on the call has had that issue. Your work has been done, a month or 2 after your work done. Hey, general, where's my money? I haven't been paid. And the general says, oh, well, sorry, I haven't been paid yet either. Well, what does your contract say? If you have a pay when paid clause in the contract, it says that the subcontractor shall be paid when the general contractor is paid by the owner. That is not a get out of jail free card for that general. They do not get a free pass. Colorado courts are going to typically interpret a pay when paid clause as imposing a reasonable time for the general to pay you if you're a sub or a material supplier from when that invoice is submitted, from when that work is completed. It is not contingent on the general contractor receiving payment from the owner. Conversely, those pay if paid clauses, those are going to give a protection to the general contractor where they do not have to pay subcontractors, laborers, material suppliers unless or until they receive payment from the owner. There's a catch. The Colorado courts are only going to enforce that protection to the general if the clause expressly states that the subcontractor will be paid only if the general contractor is first paid by the owner and that the subcontractor recognizes and bears the risk of that owner's non-payment. Unless there's that specific type of language acknowledging the risk, acknowledging the contingency, the Colorado courts are going to say, not enough notice there. We're going to treat it as a pay when paid, putting the onus back on that general to pay you within a reasonable time. The next one to be aware of is a prevailing party clause. You have an issue, you're not getting paid, you go to the general, hey, I need my money, you haven't paid me. You got to take them to court. You're spending a lot of money on your attorneys, and say, well, you owed me $30,000. I spent $10,000 with my lawyer, so now you owe me $40,000. Guess what? Not so much. Unless there is a prevailing party clause in the contract, Colorado, the rule is you do not get your attorney's fees unless the contract says you do, or unless you're suing under a statute that's going to allow them. A straight up breach of contract, that's not going to trigger a statute. It's going to give you your attorney's fees. So what does that mean to you? I was just talking about that scenario. You spend 30, you owed 30, you spend 10 on legal, you win, but without that prevailing party clause, you do not get to recover those legal fees, which means you now net 20 in order to get the 30 that you are owed. So very important to be aware of what's in that contract. Do you have that type of prevailing party clause? The other caveat to this is what we see in construction. You all are, I'm sure some of you have had this exposure, is a negligence type claim, an allegation of a defect in workmanship. Those tend to go hand in glove with a payment claim. You say, I want my money in the general, all of a sudden, well, you know what? You did not perform that work in a good and workmanlike manner. I'm entitled to offset for A, B, and C. I'm telling you about this, touching upon it in this prevailing party provision, because a prevailing party clause can be written in different ways. What you have on the screen is a broad form prevailing party clause. So if there's also an underlying allegation of poor workmanship, whoever wins is going to be able to collect, well, I shouldn't say shall, most likely. I'm not going to go into full-on nuance about when the court will award those fees or not, but you have a better a better shot at collecting those attorney's fees, including those allegations of poor workmanship on a broad form prevailing party clause like the one on the screen. Some contracts say in the event there is an action to collect fees owed, the prevailing party shall be entitled to their attorney's fees. So that's a little bit different. That's more narrow. In that instance, it's typically only going to be able to recover the fees associated with collecting on payments owed. It's not going to trigger on fees for those defending against or trying to assert claims for poor workmanship. A nuance to this came out recently, just last year, 2025, Colorado court said that if there is a prevailing party clause, not only is the prevailing party entitled to the fees to get to the judgment, to get to that award, they're also entitled to the legal fees that are necessary to collect that award. This can have some pretty broad effects, so be aware of whether you have that prevailing party clause or not and how broadly it is drafted. Arbitration. This comes up all the time. Arbitration, if there's an arbitration clause in your contract, you are saying, we give up our rights to have our disputes heard in court. We agree that we're going to go to arbitration. Pros and cons to arbitration. I'm not going to spend your time today going in depth in that, but certainly something to talk to your trusted counsel if you're looking at whether you're going to keep an arbitration clause in a contract or not. Be aware of what your rights are. But I wanted to touch upon it in particular in a lien and bond presentation. And I promise you, we're going to get into liens next, is a court is the only entity that has the jurisdictional power to foreclose a lien. So what does that mean if you have an arbitration clause? The reality is you're going to have potentially two companion cases. You're going to have to file your foreclosure action in the district court. But if you're typically doing a foreclosure with a related breach of contract, you promised to pay me for the work, I did the work, you haven't paid me, well, that breach of contract is now going to be an arbitration. The normal course of action there, you're going to have to file that bond lien foreclosure in the court to protect your timeline, because your clock's ticking, and then you're going to stay that court action while you're going through the arbitration on the breach of contract. So let's talk about these lien rights. Beware the deadlines, beware the deadline, beware the deadlines. They will catch you, they sneak up, they come up fast, and they are statutory and they are not forgiving. Mechanics liens are a creature of statute. They are strictly upheld, and so need to be aware of these deadlines. You must record the lien within 4 months of the day on the last material or labor was furnished. If you are doing, let's say you're a subcontractor, an HVAC subcontractor, you've completed the contract work, and then there's some punch list items, you got to come back and do some tweaking on some adjustment on the thermostats. That punch list type work will not extend this deadline. So that 4 months is from when you are complete, material complete with the work, punch list will not extend it. So be aware, though, you've recorded. The recording is within the clerk and recorder's office of where the work was to be performed. That's another thing to be aware of. Is this a clerk and recorder's office that has open hours? You can walk in. Do you have to do a mail drop? Different clerk and recorders now. I mean, it used to be they were open Monday through Friday, 9 a.m. to 4:30 or 5 p.m. That is no longer the case. It varies from county to county. So be aware of what that specific county's hours are and what the process is to record the lien. You're going to have to also count backwards. You're going to have to give at least 10 days notice before you record the lien. Failure to do so can invalidate that lien. The caveat I want to do a quick note here is day laborers. Those folks that are doing labor only, they're not doing materials, they got a shorter trigger. You only have 2 months to get that lien recorded. Otherwise, anyone else is going to be under that 4 months. And then you're going to have to initiate the lawsuit within 6 months of the last date of work. Now, you can, that's typically the last date of work for the project, not just your work, but if you're nervous, you're going to do it within 6 months of your work. So let's look at these deadlines when you're calculating it. Your last day to work, let's say substantial completion, January 11th. It is 4 months. It's not 120 days. It is 4 months. So you've got February, March, April, May. That's your 4. Your lien notice, your deadline now is Saturday, May 11th. Guess what? You can't record on a Saturday. And so if you calculate back your 10 days from that Saturday, if you send out that 10-day notice on Wednesday the 1st, you've just blown your lien deadline because you're not going to be able to get 10 days before that deadline. So in this circumstance, I mean, first of all, ideally you want to be doing that 10-day notice in March or April. You don't want to be cutting it to the wire. But if you're in this scenario, you're in April, you're going to want to send that 10-day notice out at least by the 30th to allow you time to have that 10 days so you can record on the 10th because you can't record on a Saturday. Things to look at on that lien statement. This is that affidavit because you're doing your mailing, you got to do at least 10 days. On the lien statement, it is a front and back, it's 2 pages. There's this affidavit where you're going to have to say, before recording the document, I mailed it out 10 days before I record it. You can't fill out this affidavit until you record. Don't fill out this affidavit when you're mailing. You got to wait until that 10 days later on that recordation. What information are you going to put in that lien notice? Got to be accurate here. You're going to have to identify all of the owners. That's even putative owners, general contractors. You're going to have to properly identify the property, including a legal description and the amount owed. So you've seen this. So here's who you are. You're the lien claimant. How much, the name of the owner, reputed owner. You can do that on looking at clerk and recorder, looking at property records. You might have 2 owners. Make sure you get them all. Who are you? Are you the principal contractor? Are you a subcontractor? Put in your information. I know it sounds redundant. You got to put it in again here. Legally describe that property. It's an amazing amount of information available online today. Then street address, the county, and then, again, who you are, and then the dollar amount. So we're talking about all these scary deadlines. Let's talk about some of these rules and exceptions. I'm going to go a little bit out of order because I'm telling you it's strict. If you do not get it recorded within 4 months from the last day work is performed, a day labor, you've got 2 months to get it recorded from the last day work is performed. All is not lost. If you're like, ooh, my deadline runs in a week. I'm not going to be able to do the notice. I'm not going to be able to get it recorded in time. You can do a notice extending. A notice extending the time to record your lien will give you an extension to get that lien recorded, so long as you record that notice within the 4 months if you're within the general rights, within 2 months if you're doing that day labor, but then you're still going to want to get that lien out right away. The nice thing about a notice of extension, you only have to record it. You do not have to give notice to do so. Be aware, you cannot you cannot do a lien on public land. That's when you're going to have a bond right. We've talked about those general labors, 2 months. If you have a waiver in the contract, that may bar you from recording a lien. So again, that's those contract terms, you want to be aware of those. Homeowner's exception, if a homeowner has paid a general contractor in full, it's going to wipe out the lien rights for everybody under that general. And then substantial completion, that's going to really be triggering that foreclosure. You're only going to have, it's deemed 3 months after abandonment, it's going to be the end of that project work. Disburser notice. This is a kind of often overlooked. This is something that you can send to the lender. So if you've gotten payments and it's going to tell you a bank that it's coming from, you can send a notice, so long as you have lien rights. You can also send a notice to the lender saying, hey, you're holding funds that belong to me. You need to send those funds to me. That can trigger liability on the lender if they ignore it. Just another tool in your tool belt as to collections to be aware of. Bond rights. As we noted a minute ago, those lien claims, you cannot lien public land. What do? There's going to be a bond. There's going to be a payment bond. If you're now, also there is also times on a private project, especially these larger ones, the general will obtain payment bonds. Those are going to substitute your lien rights generally. It's helpful. Those are, you're doing a public project, you're doing a private one where there's a bond. Get those bonds at the beginning. In Colorado, a bond is required for any state projects in excess of $100,000 and local public projects in excess of $50,000. You do not have to file a notice of intent that you're going to be pursuing payments on the bond, but it's certainly helpful. But you are going to have to do a verified notice of claim. It's going to be somewhat similar to a lien in that you're setting forth the information showing what you're owed, but keep an eye on the clock. Again, in Colorado, you only have 6 months after completion of a project to initiate a legal action on a bond claim. And this is what your verified statement of claim is going to look like. You're just going to have to fill that out and make sure you get that notarized. Okay, well, we've done all the scary stuff. Here's all the things you need to do because it's just slow pay, you're not getting paid. And let me just do a quick note on that. There's so many times in my practice I've had people come to me and say, well, they just keep saying my check is coming, my check is coming. The fact a general says your check is in the mail, the check is coming, that does not excuse the delay in pursuing lien rights. So if you're getting into that 3rd month, my recommendation, don't wait, start that lien process. But if it is successful, you are getting those payments, be aware of these 4 general types of lien waivers. You've got the during construction progress payment, and that's your conditional waiver and release. What that conditional is, I waive all rights to record a lien for the work performed to date contingent upon receiving payment. The unconditional is I've received payment and I am waiving all rights to lien the work performed up to this date. And then you've got those similar things at the end of construction. So this is your final payment app. You've got that conditional waiver. I have been paid in full for all work on the project, or I'm sorry, all work, I will waive the right to lien all work on the project contingent upon getting this payment. Once you get that payment, you get that unconditional waiver. So this is just going through those definitions for you, just kind of those triggers. Be aware of them. You don't want to be signing a unconditional waiver if you have not been paid. Those unconditional waivers are representing you've received those payments. So very important to be aware of that. So with that, I know this is kind of rapid fire. We've given a lot of information to you, but we promised to do it in 20 minutes and then open it up to you for questions. So with that, I'm going to turn it over to any questions.
Well, Shannon, first of all, you are really sensational. That was a lot of information, and you did stick to that 20-minute time frame. So thank you so much for that. We do have a question that came through. It says, does the 10-day time frame to file my lien start from the date I mail the notice of intent to lien, or when it is delivered?
It starts from the date of mailing.
Okay, perfect. Thank you for that clarification. Another question that came through, and I think you touched upon this. It says, on a private commercial job, if it has been bonded as well, can I file the lien and send the bond claim?
It really depends on the project. Typically, when you have a private project that has a bond, there's going to be language in the contract itself that says that there's a waiver of any lien rights because of that bond. In the absence of that language, you can do both.
Okay, wonderful. And then another question that looks like it's come through is a written contract required to file a mechanic's lien in Colorado?
Absolutely not. And that's why we have the lien remedy, I think, in large part. Historically, many, many years ago, although it still happens, is there's these handshake agreements and there is no written contract. Of course, there's always a contract by performance in which you're obviously doing the work. There's unjust enrichment as well. But the lien is a statutory remedy. It is governed by the statute, so you do not have to have a contract. Oftentimes, lien claimants do not have a contract to protect yourself through that remedy.
All right, wonderful. I do believe that that's all the questions that have come through. If anyone does think of another question that hasn't been addressed, please feel free to reach out, and I'll be sure to answer any further questions for you. Can you go to the next slide for us, please? Thank you. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next one, if you don't mind. Here, if you don't mind, give us a really quick moment of your time to give us that review on Google. We really do appreciate any feedback you're able to provide to us about what content you potentially might want to hear next and so forth. And then next one. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Shannon, again, you really are sensational. So thank you so much. I hope everyone has a beautiful and sunny day. Thanks, everyone.